Good afternoon, ladies and gentlemen. My name is Haroon Rashid. I hope everybody can hear me. The last time I did this, I didn't have the chat feature on, and I asked the question, can everybody hear me? And afterwards, I realized that down the left-hand column, which I hadn't clicked, there was yes, 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 yes. So on this occasion, I am assuming everybody can hear me. I can't see any videos, so I won't ask you to wave. Like I said, my name's Haroon Rashid. Welcome to Kent Worthy's Chambers. Today we're doing a seminar on document inconsistencies that lead to allegations of fundamental dishonesty. Now, before we kind of jump into that, because there's quite a lot to cover today, what I wanted to just briefly say is that I've been dealing with kind of fraud and lecturing on this and dealing with normal run-of-the-mill cases which turn into either fundamental dishonesty or, at the very least, a failure to prove. And so over time, what I've noticed is that there are small things that add up, and it's like a skittle effect where these small things over time at the end of a trial mean that the judge isn't satisfied. And these are all document difficulties which could quite easily have been remedied. Now, I'm not here to patronize, and I know it's not easy when you've got so many files to run, but some of the difficulties were easily remediable at an early stage. So I wanted to first of all just give you a kind of look at a specimen brief. And so my computer skills are not brilliant, so if you bear with me a second and I bring that up, and then if I try and share my screen, so I go there and share screen, that one. Right, you should all, that's not the right one. Let me try again. The wonders of modern technology. There we go. Right, you should all be seeing, hopefully, a CNF. This is a document that a lot of us are familiar with. I'm just pausing to see whether everybody can hear me. If somebody just types yes in the box, and then I know that I'm not talking to myself. Oh, brilliant. Thanks very much for that. We've got a few waiting in the lobby. They're joining us as well. That's the message that's flashed up. Right, CNF. CNF is the simplest and the first document. Replaces the old letter of claim. A lot of people think that the CNF doesn't really matter. It's done at an early stage within probably of the accident. So a lot of the information is still kind of evolving. The problem is when you fast forward down the line 2 years, 2.5 years, the CNF, which looks like this is one I took earlier, the information becomes crucial. Just as an indication, I've kind of circled certain parts of this, and you'll see that a claimant was accused of saying that you deliberately, or your solicitors have deliberately not put in the injuries because you must have known what your injuries were at that early stage. Why did you put just soft tissue injuries of a whiplash nature? Why didn't you mention neck, back and shoulder? Was that because you wanted to try and make the injury up afterwards? That always, it should be accurate. So it doesn't help the claimant at a later stage. Time off work I've highlighted there. And this is a full brief where we've tried to, and thank you very much to Kirsty, who's worked behind the scenes to try and redact the information from this so I could use this as an example. You will see there, claimant hasn't taken any time off work. But as I flick through this brief, I've taken out all the irrelevant documents, but you'll see later on the claimant at one point claimed he took a few days off work. I think he took a week off work, etc. And he just revolved from there. And these were all held against him. Has the claimant sought any medical attention? Here it says no. The claimant said I went to my GP 4 days after the accident. The CNF was actually completed, I think, 7 days after the accident. So the claimant was cross-examined on that. Has the medical professional recommended any rehabilitation? No, it's an early stage. The medical report did recommend physiotherapy. At this stage, it was a no. The other problem that I wanted to highlight here was alternative vehicles were all, some of these CNFs I see, these boxes are ticked no, even though the client's in a hire car. And the most, moving on to the next one in this series, what I had was a case where the claimant said that I didn't have any passengers, didn't have any witnesses. He was a taxi driver, and his statement maintained that he didn't have any passengers, so couldn't call them as witnesses. Liability was in dispute, or LVI was alleged. And what does the CNF say? So his statement says no witnesses, nobody in the car apart from me. I was alone, and the witness, the CNF says 2 people held against him. Now, individually, if you look at that, that's not a big thing. But when you start to look at these together, they start to cause grave concerns. And this is just the tip of the iceberg. I mean, I'm just going through the CNF at the moment. The most important lesson that I've learned over many, many years is this, that these forms are treated as if they're not important. But when the client is being cross-examined, they can be extremely important where there are serious inconsistencies. And there shouldn't be at that early stage. We need to make inquiries before we log on to the CNF and get this claim in the system. The next documents that I've got are the classic claim form, and then you've got the particular claim. Now, the reason I put the particulars of claim in there is this, that the account given in the particulars of claim is always important, because sometimes the standard particulars of claim done in-house, there's nothing wrong with that, but just make sure that the account in the claimant's particular claim matches the medical report, matches the witness statement. Because if there's inconsistencies, those will be pointed out, and these are basic matters where the claimant then is responsible for the inconsistencies, and it puts him on the back foot. This is again, I hope you can see the page that I'm looking at. It's page 5 of the document I've got. Again, the claimant sustained soft tissue injuries of a whiplash nature. That's being a little bit lazy. That was picked up in a case that I was in, where they said, why didn't you list your injuries then? He said, well, I didn't do it, this list is it. But you've got the medical report, because it's dealt with, medical reports there. So at this stage, we could have quite easily put in neck, back and shoulder injuries or whatever, but it wasn't. And what the defendants were alleging with this is you've deliberately kept this vague all the way through, so that you got the opportunity to change or add to it, and or you weren't sure of your injuries because you made them up because it was an LVI, so you kept it vague. It doesn't help the claimant. The last thing I wanted to cover generally before I go into specifics was interpreters' clauses. Often what happens is the clause has changed. I recently had one where the defendants have said you haven't complied with the court order, and the claimant said, what are you talking about? We filed a witness statement in time. But the statement of truth was the old one, not the new one. Relief from sanctions application, headache. So make sure that you've got that. If anybody hasn't got it by now, send me an email. I'll send that over to you. It's a standard form. But the reason I've highlighted it here is this. Claimants, if they don't speak English, the rules are getting stricter and stricter by the day. You need to have the interpreter's clause in there. Causes a lot of difficulties. Schedule of loss, schedule of damages. You've got this. Now, what happens often is in the early stages, we'll file a schedule and we think we'll deal with it afterwards if there is anything. At the stage that proceedings are issued, this should not be inconsistent. The reason I've highlighted this is actually in this particular case, my vehicle repair claim was actually £1,760, not this £2,357.98 which the engineer had calculated, and which the defendants had paid on a without prejudice basis. So the defendants were asking my guy questions saying, why have you lied? Because that's not what you paid for vehicle repairs. You've paid £1,740, and incidentally, and I'll come back to this when I'm dealing with vehicle repairs, why haven't you returned the rest of the money? So that's that. What I had here was a Part 18s. Now again, this client was asked questions, and the Part 18s actually contradicted the witness statements. And I don't know how that happens, but it shouldn't, because obviously the claimant's left in a difficulty. When he's doing his witness statement, if there are earlier Part 18s, then they should be compliant. For those of you who know me, I've got to be in my bonnet about Part 18s. Part 18s are for clarification. They're not for fishing. They're not for cross-examination. The nature of this Part 18 request was so long-winded, I would have never answered it. I do some serious injuries work and NIHL work, and I say, no, make an application. Unless Part 18s are specifically targeted to areas which need clarification, we don't answer them, simply because in this particular case, these were all the things that I've highlighted that came back to haunt the claimant because they were inconsistent with accounts that he'd given later on to the medical expert. And yet this document, the defendant sent it a long barrage of questions and sub-questions, and we simply answered them and sent them back. Why? Why can't they wait for witness statements? What do they need to clarify at that early stage? So those are there. Then you've got the classic witness statement, and I've highlighted there a couple of days. Now, he attended upon his GP a couple of days. The medical entry actually, probably from recollection, said, I think 12 or 13 days. Again, that's an inconsistency. There you see 1 week off work, which is in the CNF, it said no time off work. And then this was my favourite, paragraph 19. Bad dreams, flashbacks, irritability, loss of appetite, loss of concentration. This was a taxi driver who'd been working for a taxi driver for a long time. He claimed to have suffered neck, back and shoulder injuries, and he claimed a 10-month prognosis, severe symptoms when he was examined by the medical expert 2 months down the line. And so these were, but if I can possibly show you something very interesting, which I'm sure you'll find amusing at the same time. I'm trying to bring up a picture of the vehicle. I hope you can all see the picture of the car. I've tried to get rid of the details of it. That was the front of the car. It was an LVI. On any reading of the papers, it was a low velocity impact where somebody reversed into him. And so basically, our guy, who's a taxi driver, been a taxi driver for 20, 25 years, whatever, claimed that as a result of this accident, and that's the damage to the vehicle. I think I had another picture as well. I think there's a side picture. Let me see if I can show you that as well. Because that I can make an important point with that. Can you see that picture now? In that picture, you can see that's the side of the vehicle. I mean, there was little or no damage. You can just see a little bit down here. Yet, this guy claimed he had flashbacks, nightmares, everything else. Now, the issue isn't whether he suffered injury, because yes, in low velocity impacts, for those of you who've done it for a long time, the engineering and biomechanical expert evidence and the medical evidence suggests that even at low velocity impacts, you can suffer injury. And we've challenged those in the courts, and I've run trials on that point where we've won in court saying, look, you can suffer injury. Reason being simply this, that when you have a low velocity impact, these vehicles are designed to absorb impact above a certain level of energy. So what happens is that where it is above a certain level, the actual brackets under the bumper and the vehicle as a whole crumples to absorb the impact. Where it's a low velocity impact, we argued in court many times with expert engineering evidence and medical evidence that actually the energy flows through the vehicle. It's not absorbed by the parts, and therefore there is more chance of actually suffering an injury from a low velocity impact than a high. So that's not the issue here. The problem is the exaggeration. That's the vehicle. I mean, you can see the damage is very minimal. And so if a claimant came along and said, I had some neck pain, a little bit of back pain, and it took, X amount of months to settle down, that is believable. The problem is where the vehicle damage is almost, very minor, and the claimant comes along and says, well, I suffered injuries that were severe 2-3 months down the line when I went to see the medical expert. It doesn't quite make sense. So I'm just going to try and go back to my other slide. If you bear with me a second, if I can open my tray again. It's, I think, this one. Let me get rid of that. And let me get rid of that. Yeah, so back to this, flashbacks and nightmares was where I was on. The reason I wanted to just give you an idea, kind of a feel of these papers is the medical report. Here we are. It looks like a standard set of papers, but the amount of inconsistencies that were in this case was simply unbelievable, because the claimant had said different things to different people at different times, including whether he was off work, etc., and how his progression of symptoms happened. Then you've got rehabilitation. This was a problem. I'll deal with this in my further notes. I'm going to flick through these. You've got pro forma invoices in relation to physiotherapy, and then you've got the actual invoices in relation to physiotherapy CBT. Then you've got the bank statements, storage and recovery invoice, hire invoices, etc., etc. I'm not going to labour on those too much. What I'm going to do, I'm just going to go back to the PowerPoint and then take you through these bit by bit. So hopefully now we should be back at the PowerPoint, and if I play that, right, okay, so as my little demonstration there, using modern technology as much as I could, at first glance cases appear very straightforward, and what you often have is the personal injury, vehicle repair, hire charges, storage, recovery charges, physiotherapy charges. Those are your standard things. Now, dealing first with general problems, I've already mentioned very briefly that you've got incorrect statements of truth, inaccurate schedules of loss. You've got points that are mentioned in the defence. So often what happens is when we get a brief to prepare for trial, and the claimant's being asked things in conference, and the claimant doesn't have a clue that this has ever been raised in the defence. So it's always important to take the claimant through, because a lot of the areas that you may be cross-examined or you may need to deal with have been raised in the defence and the counterclaim. They're often not picked up. Part 18 replies I've already mentioned, not my favourite document. If we're going to reply, make sure it's accurate, and then when you draft a witness statement, make sure it's consistent. Dubious claims abandoned partway through, physiotherapy and things like that, where they're abandoned partway through, we think it's died. I had a case recently where they cross-examined the claimant for almost 15 minutes on why it was abandoned, and it caused all sorts of difficulties. So that process needs to be done before you issue proceedings and before you draft your schedule of loss, rather than partway through the claim. Inconsistencies between the CNF, medical report, witness statements I've already mentioned. LVI and engineering evidence I'll come back to at the end. The first main section that I'm going to cover is the medical injury, the injuries and the medical evidence. Now, what we often have is, first of all, the claimant's asked, when did symptoms start? Now, the claimant says to the medical experts, they started on the day of the accident. He said to his doctor, in a case I was in yesterday, actually, they started 2 days after the accident. But when he got in the witness box, it's a week after. Now, that causes a problem. So the claimants need to be consistent. And what happens is often they go along to the medical expert and they will just regurgitate whatever comes into their mind. But they need to be reminded that they need to give a full and accurate account. And they need to be reminded of the medical experts and perhaps what they said, because a lot of the time they contradict what they've said to the medical expert. And within 2 hours of the accident, I had neck, back and shoulder pain. Then it became within 2 days of the accident, because the medical record suggested 2 days. Then it became a week later, and that causes problems. Cross-reference should be made once the medical report comes in and before the witness evidence is drafted. We should have the GP notes at an early stage anyway. So if there is an inconsistency, the claimant needs to deal with it in the witness statement. What sometimes happens is that you'll have 3 different accounts. At least it should be at the very minimum, because of logistics of it and the number of claims we deal with and medical evidence and not cross-referencing. Okay, but at the witness statement stage, at least, it should be consistent with the medical evidence and hopefully the CNF and the earlier documentation and the medical records. Now, in relation to LVIs especially, always stand back and look at the nature of the accident. Look at the vehicle damage, look at the severity of the impact, look at how many passengers were in the defendant's vehicle and whether anybody was injured. Because if the claimant is saying, I had severe symptoms, I had to bed rest for a few weeks, etc., and the vehicle damage doesn't support it, challenge him on it. It's easier and better if we challenge him at an early stage rather than he be challenged in the witness box, because that's what often happens. And so where a claimant comes to you and says, in that example I showed you, an extreme example, after the accident I had flashbacks and nightmares and I couldn't sleep and I couldn't do this and I was depressed, and I've been a taxi driver for 23 years and I've had 4 previous accidents, you've got to suggest to him, come on, are you really suggesting that in this little minor accident in a car park where somebody reversed as they were trying to park, you have had nightmares for 3 months and you need CBT? Because if you send him along to the medical expert will say, yep, I believe every word he says. But when you bring the picture together, so it's better at that early stage, A, to ask the claimant the difficult questions, and B, to have some sort of vetting process to see whether this is worth going. I had one where, I have many, to be honest, where I say, pre-trial conference, we're going to struggle with this one. And the answer comes back, and this is perhaps logistically, you know, you've all heard of this, we're that far down the line, we might as well continue. And if that process had been done earlier, it would have saved a lot of time, effort and work. So that's the GP records and psychological injuries. Now, where the claimant you feel has over-egged it in the medical evidence, challenge him on it, and then you've got the opportunity for him to progression of symptoms in the witness evidence. So ask him to give you a full, proper and accurate account of progression of his symptoms. He's going to be asked that anyway. So the witness statement, rather than saying, I had a neck, back and shoulder injury, I agree with the medical evidence, I recovered in line with the prognosis, it should have, well, when I went to see the medical expert at the 2-month stage, yeah, the symptoms were as described in the medical report, but then they did tail off and I did get better and I could do more. That becomes, it's easier for the claimant to then deal with in the witness box, rather than a reliance upon simply the prognosis. The problem that often occurs is this, where you've got 8-month prognosis, 3 injury sites, the defendant's counsel will say, let's take your neck injuries. How did they all recover at the same time altogether, or did they recover one after the other? And the claimant said, well, one after the other. When did your neck injuries recover? Oh, that was 7 months, not 10. Okay, when did your back injury recover? That was 8 months. And when did your shoulder injury recover? Oh, that was 9 months. Straight away, he's contradicting his witness statement, he's contradicting the medical evidence and his progression, and everything's gone. Now, you might be thinking, well, how can we legislate for that? It's simply by the claimant making sure that he gives a progression of symptoms and he reads his witness statement. When he reads his witness statement, because a lot of these accidents, the trials are 3 years down the line, the claimant can't really remember, he needs to refresh his evidence. If he's got a witness statement which takes him through the progression of his symptoms, how he recovered, he'll say, oh yeah, I remember that now, it was 3 years ago, but I've given a consistent account and I remember it. If the statement simply says, recovered in line with the prognosis, and then he starts to be cross-examined on all these, they often struggle. Claimants often try and say, I recovered earlier than the prognosis. Now, sometimes they think that this will bolster their credibility by saying that the medical expert said 10 months, I recovered within 8. It may do sometimes, but a lot of the time it comes back to bite the claimant, because he then starts to produce inconsistent accounts. For example, I recovered within 7 months. But the witness statement doesn't actually say that, because the prognosis was 7 to 10 months, for example. The witness statement says recovered in line with the prognosis, but in the witness box now he's saying 7 months. So we need to be clear exactly when he recovered. Now, one of the most important areas when dealing with these cases is previous accidents and subsequent accidents. Previous accidents are a must now, especially if they're within a few years of the accident. If a claimant deliberately conceals those or fails to mention them inadvertently, it's going to be held against him. So a thorough check needs to be made, and the claimant needs to be made aware of that. And if, say, for example, 6 months before the accident, the claimant has been involved in an accident, not only take the claimant's word for it, but try and get the documents, because you're going to have to get them anyway, to see what injuries he's suffered and what the medical report says and what the prognosis is, and then take that as part and parcel of the new case. So even to the extent that I've had cases where the medical expert in our accident has said, yes, I have seen the medical report from the previous expert, he had neck and back injuries, he suffered neck and back injuries. In this case, that was an aggravation. Having considered the earlier report and everything else, I attribute symptoms to this accident and 30% to the old accident. Brilliant. The problem comes when there's nothing of that and the claimant suddenly giving this information about previous accidents, and he starts to, the barrister starts to cross-examine him. He's unable to deal with why he hasn't mentioned it, what the symptoms were, what the prognosis was, and everything else. These documents inevitably will have to be disclosed. They do their searches and they come back with saying, you've had this many accidents, you failed to tell us in any event. and sometimes applications are made in relation to those. One matter in these which is absolutely fatal. I've done a few trials on this over the years, and it's absolutely fatal, is where we have a road traffic accident, and the claimant has a subsequent road traffic accident, say 2 months after, is examined for the first accident at the 4-month stage, and does not mention the intervening accident, doesn't mention the accident in the middle. That is very, very serious. A lot of judges will throw that out. So the claimant needs to, when you come to the witness statement stage, we need to check the dates of examination, we need to check the dates of the accident to make sure that when he was examined, I had one where it's laughable, but 2 weeks before the examination, the claimant had an accident, but did not mention it to the medical expert. And so he had his first accident, he had a few months in between, and 2 weeks before his examination, he had the second accident, never mentioned it to the medical expert. And he tried to explain in the witness box why, but no judge was going to really entertain that. So those accidents, subsequent accidents, are absolutely crucial if they remain within the prognosis period. But it's important when there are different accidents to make sure you check the date of the examination, as well as the date of the medical report. So I've dealt with exaggeration. Time off work, I'll come back to in the higher section, but time off work needs to be consistent. If the claimant has taken time off work, check the GP records and make sure that he has. Sometimes they like to throw that in just as it makes it look a bit more serious. That is a problem. Social media. Social media is an important one. I've seen more and more of it over the last few years. Claimant, like I mentioned, do serious injuries work, and in one of my serious injury cases, claimant had a very bad back injury, but on her Facebook page, she entered a horse riding competition about 4 to 6 months after the accident. Now, that was about the time that she went for medical examinations, and she had a quite senior job. She was a manager at Barclays, everything else, and we were claiming that this affected her work and everything else. But when they produced Facebook photos and Facebook videos showing that she was horse riding, it caused significant difficulties. The potential value of the claim was over 300,000. I think we settled for around 70 or 80 in the end because of that. So it's important in the more serious cases where you've got the bigger, higher claims and the more serious injuries, just make sure that before trial cross-reference is made and the claimant hasn't got any Facebook posts which show him, on the trampoline doing somersaults or something like that. Attendance at the GP. The records are never very accurate. The earlier we get them, the better, because the claimant will always say, I went along to my GP. But if I could have, there are very few occasions where the injuries that have been given to the GP are consistent with the medical report, are consistent with the witness statement. They just aren't for some reason. At that early stage, claimants, I don't know why, but they don't seem to give an accurate account. I had one yesterday where went along to the GP 13 days after the accident, claimed that he's got shoulder pain, but when the GP checked him, said full range of shoulder movements, no tenderness, and nothing identifiable. But when he went to the medical expert 2 months after the accident, reduced range of shoulder movements and tenderness. And that was something that the judge picked up on and said, how can that be? Why hasn't he got a reduced range of shoulder? If it was 1 day after the accident, I could understand, but 13 days after the accident, and he's got, so these records are very important and they need to be accurate. A lot of the time, people go to the GP to try and document it, but it often backfires these days. GP entry, yes, the defendants will say, well, you couldn't have been injured because you didn't go to GP. Well, that's not going to carry very much weight. We know that a lot of people just turn up to GP to simply document it. So if it's not there, it's fine. But if you're going to go to the GP, then make sure it's accurate. And at that early stage, these days, we do get the claims early. So if the claimant is intending to go to the GP, just ensure that he does give an accurate account of his injuries. I've dealt with previous and subsequent accidents, and I've dealt with that slide. almost halfway through. I've got quite a lot to cover, actually. Vehicle repairs. I haven't brought up my sidebar of questions, so let me see if I can get that up. So if anybody's asking me any questions, I can deal with them as I'm going along. Questions. Nope, no messages. Good. Right. Okay. Going back to then our slide, vehicle repairs. Vehicle repairs often cause difficulty because this is crucial to the whole of our claim. The LVI allegation, low velocity impact, how much did the repair cost? The engineer's report will deal with that, but sometimes the vehicle repairs invoice is important as well. Where was the vehicle repaired? When was it repaired? Who was it repaired by? Are often questions that the claimant will be asked, and these are seldom dealt with in any of the evidence. All one we get is a repair invoice, and often that's missing as well. I had my vehicle repaired from a local backstreet garage, and that, unfortunately, where there's allegations of fundamental dishonesty or suspicions, it doesn't help. Repair invoice amount does not tally with claim and engineering report. In the example that I showed you, I did point out that basically what happens is that the engineering report comes back and says £2,200 worth of vehicle damage. We said to the defence, can you give us the check for that? They send a check, but our vehicle repair is only £1,700, and they all should tally. And the claim that's made in the schedule of loss is for the full amount. And so the claimant's left in a situation where, can you explain why you didn't return the extra money? Because we paid you £2,200. This is a question that was asked. We paid you £2,200 as an interim on a without prejudice basis to get rid of hire for your vehicle damage. You had your car repaired for £1,760. You've now produced an invoice, but you've never returned that money. You've never given credit for that money. Where did it go? And I had the classic answer. I had the answer that it was deducted by way of a fee by the management company, or words to that effect. And you can imagine in court how that sounded. Right, the quality of the repair invoice, and in the documents I had, I won't go back to because it's quite tedious to try and find it, but I had a repair invoice from a so-claimed backdoor garage, and it didn't have a full address, didn't have a postcode, didn't have a phone number, didn't have an email address, nothing like that, no VAT number, but VAT was claimed on it, and so it wasn't worth the paper it was written on. If the claimant produces something like that, we've got to challenge it early, rather than simply take it and put it in the bundle and say, right, there's the repair invoice, that box is ticked. It will come back to haunt him. So if it's a very flimsy and poor invoice, just challenge it and say, we need a proper invoice if you can provide one, because the quality of the repair invoices are all over the place. Date of repair is also important, because sometimes what happens is that the claimant goes along and tries to, we ask for a repair invoice, and he goes back to the garage and says, can you do me a repair invoice for the car you repaired last year? And I know you, you know me, yep, do it. And the date they put on it is totally inconsistent with the date the vehicle damage check came in, the date he claims that storage ended, the date he claims that the vehicle was re-inspected by the council because it was a hire vehicle, etc. And so the repair invoice then becomes a document which is alleged is fabricated, and so therefore you're down the road of fundamental dishonesty again. Where is it arisen from? Dates haven't been checked. The other matter is if the claimant, what happens sometimes is that defendants will say, you need vehicles a write-off, you need £3,000 to buy a car, but we're only prepared to give you £2,000, or they make an interim of £2,000. Claimant claims he bought a car for £3,000 or £4,000. Where did he get the extra money from? He can't show it in bank statements, he can't show it anywhere else, and that's important. So when the claimant bought the vehicle, where he bought it, who he bought it from, how he replaced it, all these matters can potentially lead to grave difficulties for the claimant. So they need to be just checked to make sure that we dot the I's and cross the T's. Now the next one is higher charges. Sorry, I've just accidentally reset the slide. So I just go through higher charges. High charges often cause problems because the claimant will say, I took a week off work. In the example I showed you, there was a week off work. He was hiring a car at £200 plus CWD and collision waiver damage, I think it's called, and VAT. It's working about 200 and something pounds a week. His account showed he was earning 80, 90 quid a week. He took a week off work, and he was pretending he's impecunious, obviously, and well, when I said pretending in this particular case that I did, because I'll explain why I use the word pretending in a few moments when we go to his bank statements. But in this particular case, he was saying, I'm impecunious, I've got no money, I had no alternative but to hire, and the witness statement and the medical report suggest he took a week off work. Hire started the day after the accident, so this vehicle sat on his drive, accruing £1,800 worth of hire charges, and he couldn't work. He was too injured to work. That straight away puts him on the back foot. So it's important to make sure that we check when the hire starts and why he put sat a vehicle on his drive for that long when he didn't need it. So that's sorry, go back one. What have I done there? Yeah. Has the local authority been informed that the vehicle was unroadworthy? Obviously, where it's a hire vehicle, the local authority needs to be informed, but a lot of this is self-reporting. And this is the point I wanted to make. Sometimes what we say is that, oh, the local council actually deemed the car unroadworthy and they took it off the road. But more and more these days, it's self-certification, especially in the COVID era. So in one of my cases, the claimant, he said, oh, the car was unroadworthy, the council declared it unroadworthy. But during evidence, it came out that actually he declared it unroadworthy. It was all done online. He went online and said, my vehicle is now unroadworthy because I was involved in an accident on X date. And so he was left with looking a bit silly in the witness box because he'd suggested that he'd hired, etc., because the council had deemed his car unroadworthy. So that is important to remember. If it has been deemed unroadworthy by the local authority, then that evidence needs to be produced. And a lot of the documents that we receive now do have quite a lot from the local authority, but that is something that occasionally is missing. Now, compliance with court orders in pecuniosity documentation, most important. I'll start with this. I had one where the accident was in May, I think it was the 22nd of May or 3rd of May, and we needed to disclose 3 months bank statements before the accident and during the hire period. What we did was we thought we'd complied with that, but we didn't check the dates. Our statements started mid-February, so we missed about 10 days off. So instead of starting from the 2nd of February, they started on the 15th. We couldn't rely on impecuniosity. And so that caused all sorts of problems. And so that's very important to check the dates and make sure that we complied with them. While I'm on that topic, I may as well deal with the last point on that slide, bank statements. Bank statements, claimants will often try and say, this is the only statement I have. We need to check through them to make sure that bills are going from that account. If bills are being paid from that account, mortgage is being paid, and daily expenses are going from that account, he says, this is my own account, it is plausible. But where there is no mortgage, nothing else going from that account, and seems to be occasional transactions here and there, and the smoking gun, which is transfers to another account, he hasn't complied with his obligations, and that will cause significant problems. My favourite one I had was, I will try and exit this and show you some bank statements where we had the classic sort of difficulties. If I can try and find those, bear with me a second. So, here we are. So you've got the real details have been redacted on this. You've got the classic sort of bank statements. Now, what a lot of us do is we look at these and think, it's fine. It's important to see what is happening, because I had one case where a claimant was paying, I think £1,000 a month for some into a holiday account. I think you can open an account where you can save for a holiday next year, and he was doing that. And he was asked the obvious question: if you've incurred £20,000 of storage and recovery and hire charges, and yet you have got another account somewhere where you're siphoning off money for a holiday, why couldn't you use that in this emergency? You've got your working tax credits coming in there, you've got everything else. In this case, I'm just trying to find the relevant page. There were 2 big deposits going into the account. Now that's what you've got to look out for, big deposits coming in, which basically need to be explained. In my case, some of you will laugh, but the claimant was asked, you put £1,000 into your account about a week or so before the accident. Where did that come from? And he said, that was money at home and under the mattress, so to speak. So they said, well, why didn't you put it in the account? He goes, no, what I do is I save money at home. This was on the cuff, his reply. Said, I save money at home, and when it gets to about £1,000, I can't keep it at home because it's not safe. So what I do is I go along to the bank and I put it into the bank. And I could see what was coming because I'd seen the second entry a week later, which showed another £1,000 going in. So, but at that stage, so all these, the claimant needs to deal with bit by bit the transactions in his statement. And if there are any big deposits into the account, he needs to explain them. In my case, he simply wasn't able to explain them. And so the bank statements will often cause difficulties. The other question that they're often asked is, do you have a joint account with your wife? You must have. And they say, yeah, I've got a joint account. Why haven't you disclosed it? There goes impecuniosity. So all the work that you've done behind the scenes to try and get all the documentation in order, the spot hire rates, all the bank statements, all the hours you've spent can be gone with one reply from the claimant. So it's important to try and pin them down and say, you need to record this. I've had at least one case, the allegation was FD, where the defendants have, using databases, tried to show that the claimant has got these accounts that he hasn't disclosed. So that is always a possibility. It's only happened once, but I think it's going to happen more and more as we carry on in this area, where the defendants want to challenge the claimant on his impecuniosity. The date the vehicle check was received and hire ended, there is always difficulty here, because sometimes the checks received, the claimant's been saying that I couldn't get my vehicle repaired because I didn't have any money. As soon as the check's received, the hire ends. And that may sound good, but it doesn't actually, because when the check's received, it's received by the solicitor. Solicitors then process it, send it to the claimant. The claimant then has to bank it, and that takes time for the money to come out. Then he has to take the vehicle out to storage and contact a garage, get it repaired and get it back on the road. And so in cross-examination, once he said that, he's stuck. How can he take the vehicle out to storage, and how can he end the hire when his vehicle's still in the damaged state? And so in my case, they were trying to show that this was a sham agreement. And so it's very important to have these dates. And I did a seminar on hire, I think last year, but what I said there was this: in any taxi hire case, you probably get 8 to 10 weeks worth of hire, even if you didn't have one shred of evidence in relation to impecuniosity, etc. Why? Simply because before this COVID era, what you had is the claimant needed to tell the local authority inspects, makes the vehicle unroadworthy, they issue him with a notice, he goes and gets the vehicle repaired, he gets it repaired. In some cases, depending on the type of vehicle, if it's one of these big vans or etc., it needs to go for a special test. I think VOSA do some of those, and then the council need to retest it. By the time council retest it, their waiting dates were quite long, sometimes 10, 12, 14 weeks. So in cases where we had hire, I've got 3 or 4 months worth of hire where I've got no documentation, sometimes even longer, because that's the process. And sometimes we don't realise that, we get ourselves kind of tied up in the dates. And so it's important to make sure that all the dates tally up. And if they don't, challenge the claimant and see where the problem is. It may be that one of the documents has got an incorrect date on it. We don't know. When it's in the witness box, it looks really bad, because the claimant, it seems to be the fact that the claimant's got his check in the morning and has his vehicle back on the road by the evening, and it doesn't make sense. Documents for hire vehicles, as you all know, is becoming very popular these days. The reason I threw it in there was recently we're dealing with a couple of cases where the vehicles that were hired to the claimant after his own vehicle was damaged were covered by an insurance policy which only covered courtesy vehicles for the MOT and repair garage, which ran the accident management as a side business. So the actual hire vehicle wasn't insured to drive. So it's always important where the defendants challenge these sorts of things in the defence. You can't do it early on. It's impossible to do these things I'm saying at the start of the claim. You'd be thinking, no way. But at that stage where you're going to trial, you're going to issue a claim, these are the important things to make sure that the ends meet. So documents for the hire vehicles are another. One I've had is signatures. One thing where you're partway through the process is to sit back and look at the signatures that the claimant has given in the early days on the particular claim, if he signed them, schedule of loss, then his witness statement, the hire agreement, the hire in, all these documents that he signed, because sometimes, unfortunately, what happens is, especially where there is a longer hire, it may be a case where people can't be bothered doing things correctly, so they try to copy signatures. And I had one a few years ago, I think it was a couple of years ago, where the signature on one of the hire agreements was absolutely identical to the T. You could put them over one another, and it was absolutely identical. Yet these were 2 or 3 different hire agreements. And that's what the defendant suggested. The defendant suggested the claimant hadn't signed them, because when he went back, they just gave him another car, and they just put one paper over the other and traced it. And that causes problems. And so when signatures don't match, so his signature on his witness statement didn't match any of the other signatures, and so the claimant was left in considerable difficulty. And so all that needs to be, we need to ensure when we're at in the proceeding stage that all the signatures match. And if they don't, ask the claimant, why does your signature change? Why doesn't it match your driving license? Why doesn't it match the council documents? Why doesn't it match here? And sometimes the reply is not what we want to hear. So that's a hire agreement that we need to make sure that we've covered with the claimant. Just a quick point there. It's sometimes prudent. What happens these days is that, as far as impecuniosity documentation is concerned, there is a lengthy statement from spot hire rates is what I meant. As far as spot hire rates is concerned, there's a lengthy statement from one expert, the other so-called experts, who just then have a load of data at the back. And for the judge to sieve through that to try and find what the appropriate rates are is very difficult. Sometimes 30, 40 pages. So it's always useful to have an agreed summary that, as a summary, the defendant's expert says these are the spot hire rates that are appropriate, and then the claimant's expert says these, and those will make life easier for the judge. The other one point before I move on from hire is that I have dealt with a case where my hire vehicles were never repaired in 2 years worth of hire, never went back into the garage for a service, and never went for an MOT because we couldn't produce any documents to try and show that. And that doesn't really wash with when you're in court being cross-examined, or the client's being cross-examined on that. The client won't be able to answer. He will think, how do I deal with this? When did I take the vehicle back? How did it? So all these things need to be canvassed for them, need to be kind of put to him early on. Time's flying by. I'm going to very quickly move on to my next section, actually. These are all kind of issues which we could talk for some time, but I think physiotherapy and CBT, this is an area which has really shot off over the last few years. In almost every case now, you'll have a CBT invoice, a physiotherapy invoice, and it's done in-house. My favourite ones are ones that have the same address as the accident management place. Physiotherapy is carried out in the front reception, and sometimes it's done over the phone. And then there have been times where the claimant said, I only had 2 sessions, but 7 sessions are claimed. So the location where it's carried out, the actual quality of the invoice, VAT numbers, and all this needs to be checked thoroughly to make sure that it all ties up, and the claimant agrees that he's had these sessions. I had one where he claimed that he had some sessions at the office of the claims management company, but some of the physiotherapy sessions were done over the phone. Now, CBT sessions over the phone, I can understand how one can do physiotherapy. Some of you who are thinking on your feet might say, well, he was advised to do exercises, but how can you do that every week or every 2 weeks? And especially when he's being cross-examined and saying you're exaggerating your injuries because this is an LVI, it then all fits together. And it's the bigger picture. It's like the 10-pin bowling analogy where one skittle goes down, it's fine, two go down, it's fine. And when lots of little skittles start to fall, the judge starts to think, hang on a minute, there's something not quite right here. The other one that is difficult now is this. When you've got the CNF, when you've got the medical report, when you've got the claimant's witness evidence, and there are inconsistencies between those are bad enough to deal with, or making sure that everything's consistent. Now these physiotherapy companies, to try and justify an initial assessment cost and a discharge report fee of £85, they do a discharge report and an early assessment report. And that early assessment report doesn't tie with the medical evidence. In fact, sometimes it contradicts it or adds extra things in. And the discharge report doesn't make sense as well because it contradicts the claimant's witness statement, for example, or something else. So at the 8-month stage, the claimant says, I recovered, but physiotherapy ends 2 weeks before, and so it says it's still got ongoing symptoms. So unless he miraculously recovered within a week. So that needs to be looked at very carefully. We're adding extra detail in, which comes back to haunt the claimant. The last area, before I go into some general comments on this, is storage and recovery. Storage and recovery invoices. This is an area that causes the claimants a lot of difficulties. I had one a few weeks ago where the claimant had incurred £3,500 worth of storage and recovery charges. The claimant said that he drove the vehicle after the accident, he went home, and it was the next day that he informed the local authority that the vehicle was damaged, and the recovery company came to his house and recovered the vehicle from his house. The recovery invoice suggested vehicle recovered from scene of the accident. Storage charges started on the day of the accident, whereas the vehicle was recovered the next day, causes problems for the claimant. And so those need to be consistent. My favourite one is vehicle was dangerous, I couldn't leave it outside. You remember the photographs I showed you earlier on? I've only got 5 minutes left. I'm not going to try and toddle between those. The photographs I showed you of the vehicle that was barely damaged, that claimant in his witness statement, I wish I could show you now quickly, but he said, my vehicle was so badly damaged that I could not leave it outside because it was a danger to passers-by, and it was a danger to small children playing in the street. And you've seen the photographs. Now that doesn't wash. So if the claimant is going to be saying that, he's going to get himself into serious difficulty. The other one I had is, it's the era of Google Street View. I can drive down any one of your streets and in the virtual sense and see whether you've got a drive or not. So the defendants will do that. I had a claimant who had a long drive leading to a garage. So when I asked him, why didn't you park this vehicle on the drive? He said, well, I've got a car, wife's got a car. So why should we be parking our cars on the road when we could just park on the drive? So you could have saved, you're saying you're impecunious, you were living on the poverty line, you could have saved yourself £3,500 worth of liability simply by parking your vehicle where the rest of the people in the street, and you could see the street was full of cars, were parking. Park one of your vehicles there, park the damaged vehicle at the front. Oh no, I didn't think of that, or I didn't want to do that. It all detracts from his arguments of being impecunious and being in difficulty. Storage dates are important. They need to be very thoroughly checked because sometimes the vehicle has been moved about from one storage yard to the other, and when it comes to inspection, the engineer has inspected it at one place, and then the invoice is from another place. So the dates and where the vehicle is stored are all important. My favourite one is mileage. The engineer inspects the vehicle 7 to 10 days after the accident, records the mileage. When the defendant's engineer goes to inspect the vehicle in the storage yard 2 years later, the mileage has increased by about £8,000 to £10,000. The damage was only minor. And the obvious suggestion was this is all a sham because he's been driving the vehicle in the interim and now he's just taking it back for it to be inspected. So all of these need to be checked. So mileage checks as well at that later stage when you're looking at inconsistencies. So if it's pointed out in the defendant's engineering report that, look, when it was inspected there, the initial inspection showed a mileage of 85,000. When I inspected it, it showed 95,000. There's a £10,000 difference. Get onto it straight away and say to the client, what the hell's going on? Speak to the storage company as well. Alarm bell should be ringing. I'd rather the ring at that stage than, and all hell breaks loose at that stage, than in the witness box, because then you're looking at finding a FD. Does the storage yard exist was the last one I've got there. I've had one where the storage yard doesn't actually exist. So the defendants have driven down, knocked on the door, there's a unit and there's somebody else there operating from there. Storage yard doesn't exist. It's an old accident, 2 or 3 years old. So some of you might say, well, it could have moved. The problem is my storage is ongoing. And so that causes a problem. So wherever these are highlighted, now, again, like I said, we might not be able to guess these at the beginning, but as the claim is progressing, the schedule, the counter schedule, the defence, and dotting the I's, crossing the T's at that later stage, when we're doing the witness statements and doing the directions and checking the documentation, at that stage, we need to go through all of these and make sure. In that particular case, the defendants pointed it out that there's no storage yard in existence. So, we have to deal with that. So those are some of the main ones. The last couple of points that I wanted to make, and I've just kind of come to the end of the time, is that defendants will carry out experience searches on the vehicle previous accidents. So there's a category D where the damage was, and if they have carried those out and disclosed those, disclosure happens early. Show the claimant and check with him, and make sure that your engineer comments on that if that's come out later, so that you've got an accurate value of the total loss of the vehicle or the repairs, etc. Pre-existing damages allegations often surface. Where the defendants have got a compatibility report or a report saying this was an LVI, injury could not have been suffered, they produce a report. This is an academic area, and some experts say injury can be suffered, some say they don't. Like I said, the main theory that it is that the vehicle doesn't absorb the impact and the energy, and so it travels through the vehicle. There's an argument on both sides. So what the best thing to do is, where the defendants have got this evidence, don't just rely upon your engineering report, because you'll be stuck. The judge only has one-way evidence, so that he will prefer the evidence of the defendant's expert. Where your expert then deals with and says, no, I think injury can occur. The judge says, well, I've got one expert telling me injury can occur, one expert telling me the injury can't occur, so I'll leave the expert's evidence and I'll decide this on the old Casey basis of, how credible the claimant is. Fine, we've dealt with their evidence. But where we haven't got that evidence and we've got one-sided evidence, it causes problems for the claimants. Photographs of the vehicle damage, the quality of the photographs, if the vehicle damage is there, but it's not the greatest of vehicle damage, but it does exist and it's there. Sometimes we have these little small thumbnail photographs in the trial bundle that just can't see the damage. And so the defendants are saying, well, it's so minor, you can't even see it. But the claimant's saying, well, no, there's all this there. Try and get good quality photographs as early as possible. Usually the engineers will have the JPEGs, and you can then get them and make sure that you've got a nice big version of the photograph which shows the damage and shows it clearly. I had one where the defendants were claiming it was a bus accident, and the defendants were claiming that it was just a rivet on the bus that hit our car and the damage was extremely minor. But when my intuition solicitor got a photograph of the bumper and blew it up, and it just had the side of the bumper, it was brilliant because it showed all the scratches, all the minor dents and all the minor marks, and it showed that the defendant's account of just one rivet going along it didn't make sense. And that was all because the photographs were there. Otherwise, the claimant would have struggled. So photographs are very, very important. Right, I've come to the end of those main points that we need to kind of bear in mind. I'm just going to look to see whether there's any questions on my thing. If anybody wants to ask any questions, you can unmute and ask me directly, or you can put type into the chat box, and I'll try and answer them if I can.
Hi, Haroon.
Hi.
Hi, it's Teresa from Walker Wise. You okay?
Hi, Teresa.
Hi. Just got one question, Haroon, on bank statements, if I can. I know you stated that obviously we need bank statements from the claimant and any joint statements. Do we also need statements from a spouse or partner that they live with, or is that not?
No.
Is that not necessary?
If the partner statements are personal statements, it depends on how the claimant gives his evidence. Usually my argument is that we don't need the partner statements. Her account and his or her personal finances are their thing, just because the claimant's been involved in this accident. Any joint statements, yes. But the problem with that occurs is this. And when the claimant gets into the witness box and says, well, I use my wife's account as well, or we share things, she does some of that. And when he starts cross-referencing accounts, or when there's transfers to and fro from his account to his wife's account and they're interlinked, then you probably need to. But if they're two separate accounts, I've always argued that wife's accounts or husband's accounts, for that matter, and the reason I say wives is often it's taxi drivers and they're usually male, but not necessarily. So that's why if it's a run-of-the-mill case, I would say no, wife's accounts don't need to be disclosed, but joint accounts do. But if there are links and there's a suggestion, then perhaps they do.
Okay, thank you.
Anybody else? Any other questions? Just checking. Right. Well, I can't see any more questions there. I hope you found that helpful. It can sometimes be a difficult task because these are little matters where the claimants over time kind of give inconsistent accounts. But unfortunately, it's not an enviable job, but our job is to try and filter these mistakes out as early as possible to try and rectify